3, 2, 1, start. The services of some of them had been terminated within 1 or 2 years from the date of temporary appointment. Full stop. Though the state had taken a decision to terminate all those who were appointed on consolidated wage basis, comma, the other respondents continued because of the interim orders by courts. Full stop. Service for a period of 1 or 2 years or continuation for some more years by virtue of final orders under challenge, comma, or interim orders, comma, would not entitle them to any kind of relief either with reference to regularization nor for payment of salary on par with regular employees of the department. Full stop. If there was a one-time scheme for regularization of those who were in service prior to 1/5/1995, there cannot obviously be successive directions for scheme after scheme for regularization of irregular or part-time appointments. Full stop. Para. The first matter relates to persons temporarily appointed as full stop assistant superintendents in 1985 and 1986 in added hostels. Full stop. The prefix assistant was omitted in 1996 and thereafter the respondents were known as superintendents. Full stop. Para. The second matter relates to a person temporarily appointed as a superintendent in an added hostel. Full stop. They filed writ petitions contending that they were employed on full-time basis and were discharging functions similar to those of superintendents in government hostels, but were being paid only a meager salary while their counterparts in government hostels are paid much higher pay scale in the category A and B hostels and in category C hostels. Full stop. They sought regularization in the posts of hostel superintendent from the date of initial appointment and payment of salary on par with hostel superintendent of class 3 hostels of the welfare department. Full stop. The respective respondents in the remaining 8 appeals, claim that they were appointed in the years 1995 to 1998, as part-time cooks and chowkidars in government hostels run by social welfare department. Full stop. They claim that their appointment orders were issued by the respective mess committee of the hostel where they were employed, that the state government was paying a fixed amount of rupees 600 per month in the form of aid to the concerned hostel mess committee, which, in turn, was being paid to them as remuneration. Full stop. Para. The state government issued an order dated 28/12/1998, stopping the practice of appointing class 4 employees on consolidated wages and to remove any person appointed on that basis. Full stop. By subsequent circular, the district social welfare officers were directed to remove part-time chowkidars and cooks employed by the department with immediate effect and replace them by ex-servicemen or widows of ex-servicemen. Full stop. In view of the government directives, the respondents apprehended their services may be dispensed with. Full stop para. In the first 7 appeals, a learned single judge by a common order allowed the writ petitions. Full stop. He held that the writ petitioners working on the posts of superintendent, cooks and chowkidars are entitled to salary on par with the salary which was paid to their counterparts holding similar posts in the hostels run by the Social Welfare Department of the state government, with effect from the dates of their respective writ petitions. Full stop. He also held that any attempt to terminate the services of employees working in the hostels on consolidated salary was unjust and illegal, and therefore the writ petitioners should be permitted to continue to work on the posts which they were holding as on the date of filing their respective writ petitions. Full stop. He directed the state government to frame a scheme on the same lines in which the state government had earlier framed a scheme relating to part-time cooks and chowkidars bracket open who were serving as on 1/5/1995 bracket close full stop. He also quashed the orders which directed chowkidars and cooks employed on consolidated wages should be removed with immediate effect and should be replaced by ex-servicemen or widows of ex-servicemen. Full stop para. The scheme referred to by the learned single judge was the scheme which was framed by the state government in pursuance of the directions of the Rajasthan High Court in Anshkaleen Samaj Kalyan Sangh, which was approved by this court in 1996. In state of Rajasthan versus Singh, stop. Feeling aggrieved, the state filed appeals which were dismissed by a common judgment dated 16/8/2004. Full stop. The said judgments are challenged in the first 7 appeals by the state and its functionaries. Full stop. In the next 2 appeals, a learned single judge by common order allowed the writ petitions of the respondent in terms of the following directions issued in Anshkaleen Samaj Kalyan Sangh: it would be just and proper to equate chowkidars and cooks employed in the hostels run by the government or government aided institutions. Stop.